Well, a lot of explanations and things have already been said about the appointment of mediators and neutrals. But to add to this briefly, I would say that the procedure has been prescribed in section 89A of the CPC, and Sindh High Court has adopted this, and in that regard, Mr. Justice Adnan Iqbal Chaudhary, who is heading the ADR committee of the Sindh High Court, has already made efforts to advertise this and to call expression of interest from various people who are into mediation. So firstly, as you all are aware, that the mediation centers can be accredited with the High Court, and already we have 2 mediation centers which have been approved or authorized for this purpose. One is the MICDR, this is Musalia International, being managed by the Legal Aid Society and Mr. Justice retired Arif Hussain Khilji as its managing director. The other one is the IBA Dispute Resolution Forum, established by Mrs. Merchant. Then the requirement of 40 hours training is there for a mediator, and any individual can also approach the High Court pursuant to the advertisement and can be enlisted as a certified mediator, as a mediator to whom cases can be referred. The third is like the district judiciary, out of which many judges have been trained by the Sindh Judicial Academy, and once again through Mrs. Naveen Merchant, who is a certified trainer, so as a master trainer. So there are like 20 or 25 maybe judges from the district judiciary who have already been trained and are working with the Court Annex Mediation Center. So this is like the process over here. In Islamabad, what I have noticed is that they have their own Act of 2017 and their rules have been notified. Over there, perhaps the conditions are somewhat differently notified, I believe. And over there, 7 years standing is required for a lawyer to become a neutral. And then some retired judges, judicial officers, civil servants even can be appointed as neutrals, ulamas, jurists, and experts and professionals. So this is like the requirement and the procedure being adopted for appointment of neutrals in Sindh High Court. Okay. Now, secondly, our focus as of today of the judiciary, speaking on behalf of the judiciary as a whole, is that under the aegis of Justice and Law and Justice Commission, a committee has been formulated, and our main focus is on mediation for the reason that we cannot take care of so many cases. So our priority perhaps is to the court annexed mediation, which is like a quick way for taking disputes to mediation. And in that regard, you may appreciate that logistic facilitation is the first and foremost thing which is available for court annexed mediation. Then it gives the litigant a sense of confidence in referral of its matter to the ADR center. And these kind of mediation centers, court annexed mediation centers, are successfully working in Beijing and Kuala Lumpur, as have been visited by Mr. Justice Adnan Iqbal Chaudhary. A judge member or a judge mediator is better equipment to evaluate mediation when the case is put up before him, and is generally perceived as an expert in law applicable to the dispute. So this is also one of the reasons that we want these court annexed mediation centers to work more. And there is one thinking that perhaps this court annexed mediation center is kind of free service. So it is not as that context, because the cost is there, but the cost is being borne by the court, in fact. So we need to keep this in mind as well. And insofar as the district judiciary is concerned, I would like to inform that as of today, perhaps 48,000 approximately, 48,000 civil cases are pending before us. And out of those, there are 18,000 family cases. So we intend that these cases which can be mediated should be referred for mediation on a priority, and people be convinced to take these cases to the mediation centers. And lastly, there are 2-3 discussions about okay, why mediation has not been that successful as it ought to have been. So my personal opinion, I will share my personal opinion in that regard. There are two things which I think are the biggest impediments. One is our mindset. Our mindset has to change, that instead of going for litigation, I have to go for mediation. We have some ego problems. In family matters, we have seen we are revengeful. We want to take the case to the fullest extent. We do not want to settle petty matters in family disputes. So this has to change. And secondly, and the most importantly, is the element of a lesser cost on losing your case, no cost on losing your case. In international jurisdictions, you may have noticed that mediation is successful because the losing party pays the entire cost. Over here, we do have costs, but those costs are not documented actually, or we don't award those costs as a natural course. So it should be mandatory that the entire litigation cost and the actual cost which the lawyer has taken, with invoice and without invoice also. So only then you can convince people to go for mediation, and the consequence of that cost may be one of the reasons to persuade. And lastly, for the lawyers, we have seen that there has been reluctance because they are making good money in litigation, so they have to forego something and not being too selfish in these matters and try to convince that this is the case which can be mediated. We won't go for litigation into it. Thank you.